ladies and gentlemen, and welcome to this session on the European Foundation Statute. Welcome also to those watching on the live web stream that we are recording here, so that you're aware. Welcome to this session. It's slightly different in terms of lineup compared with what is announced in the program, and I'd just like to begin by clarifying some of those changes. First of all, I'd like to welcome on my right Kjær, Deputy Director General of the Danish Business Authority, which is the body responsible for regulation of the foundation sector in Denmark, who has very kindly agreed to join us. And I must also provide apologies on behalf of Martin Frohn, the head of unit responsible for this file at the European Commission. He had to cancel at the last minute, unfortunately, citing the need that they have to be available at meetings in the Council and Parliament because they're handling so many different files at the moment in the field of European company law. But it's important to say that despite him not being here personally, there's been a very open and regular dialogue between the EFC and the Commission in terms of not just the development of the proposal, but also the ongoing process. And a little bit later, I have the pleasure and honor to read to you a personal message from Michel Barnier, European Commissioner responsible for the internal market, and he's responsible for proposing the Foundation Statute. We have one other speaker who doesn't need to be apologized for because she will be here, but she's a little bit late. That is Evelyn Regner, member of the European Parliament and rapporteur on the statute, whose report was adopted just yesterday by the Legal Affairs Committee. The other two speakers on the panel here, we have Jorge Carrera, Councillor of the Spanish Parliament Representation to the EU in Brussels, who has been representing Spain in the working group that's been working on this in the Council. And we'll explain a little bit more about this procedure later. And finally, Søren Hansen, Professor at Copenhagen Business School and an expert on foundation and company law. Welcome to all of you. Now I'd like to kick off by posing some questions straight to the audience. I think it's important when we have this discussion that we have an idea about where everybody is in relation to this question. So the first question I have for you, is there anybody in this room who has never heard what the European Foundation Statute is? Okay, so that's a good sign. That's nobody. So those of you who have, how would you say gauge your level of knowledge on the subject? Are you experts? Are you sort of, you've heard about it, you don't know? Are you in the category, you've heard about it, but you don't know too much about the details? Yes or no? Okay, a handful. And you know it really well. Two more, okay. We should at least be able to have a discussion amongst ourselves based on a good common knowledge that at least the statute is there, why it's there, and so forth. Then another range of questions. How many of you have already spoken to your national governments about the Foundation Statute proposal? Not so many. Not so many. I'd say about a third. And how many of you would be interested, know or work with a foundation that could be interested or would support initiatives that would make use of the European Foundation? Okay, a handful. Maybe 20, 25%. Okay, important. Maybe I should ask another question then. How many of you definitely would not be interested in making use of the Foundation Statute? No one. Okay, so there's work to be done. Okay.
Very good public opinion.
So let's move on to the panel discussion before us. What we're going to do is we're going to hear from the panelists first of all. After each presentation, there will be an opportunity to pose some specific questions to their presentation, and then we'll open the floor finally at the end to everybody else. I'm going to ask you a quick introduction, first of all, to where we are. I think it's good to know that all of you know what the Foundation Statute is about, so I'm not going to start by explaining long history. But just to recap where we are in the process. The European Commission presented a proposal in February of 2012 for a statute for a European Foundation. The proposal is a very full one, a very interesting one. It's important, first of all, to remember it has nothing to do with reforming national foundation law, but about creating an additional, optional legal form for foundations with activities in more than one member state. It's a proposal that tries to strike a balance between being, on the one hand, accessible and attractive to foundations so that they actually make use of it. On the other hand, that it has a high level of credibility and trustworthiness so that it's a form that cannot be abused. It's also an innovative proposal in the history of European company law in the sense that it has some provisions, for example, on the tax treatments of foundations and their donors and beneficiaries. Now, for the proposal to be adopted, it has to be approved unanimously by the Council of Ministers, representing the governments of the soon-to-be 28 member states. It also has to obtain the consent of the European Parliament, which means that the Parliament can accept or reject the final proposal, but cannot formally amend it. All it can do is make suggestions, which the Council is then free to either take up or ignore. So just over a year ago, in April 2012, a technical working group was set up, or rather a working group that already exists within the Council was charged with examining the file. So representatives from officials from each member state have been examining the proposal. And that was a process kicked off by the Danish presidency, which is why we're particularly grateful to have a representative presidency here of the Danish government. This group has held 4 meetings so far and discussed every single point of the proposal in detail. Since then, now it's the Irish presidency of the Council. They've tried to take into account all the concerns that have been raised by the member states and have tabled an amended compromise proposal, which will be discussed at the next meeting of this group at the end of June. In the meantime, there have also been opinions from the European Economic and Social Committee and the Committee of the Regions, both positive. And finally, as I mentioned earlier, yesterday the Legal Affairs Committee of the European Parliament approved its report on the statute, supporting the statute with a number of suggestions for amendments. So, we have the proposal on the table. The concerns of member states are becoming clearer. And now the question for foundations is to listen to these concerns raised by member states, to try to propose solutions that will make the statute an effective legal instrument, and finally, of course, to convince their own governments that the statute will be a useful instrument used to promote philanthropy in Europe. So far for my introduction. I'm afraid you're going to have to hear me a little bit longer, but that's not me speaking, but now Michel Barnier. I will just read out the note that he has sent to kick off this panel discussion. The Commission would like to thank the European Foundation Centre and the foundation sector in general for their support for the Commission's work on the European Foundation Statute. The proposal is very important for me, as I stated when I took position as EU Commissioner for Internal Market and Services at the occasion of the audition in front of the European Parliament. For the Commission, it is clear that foundations stand at the heart of the social market economy. They serve European citizens in areas that are important to them and to the European economy. Social and health services, research and culture, to name just a few. However, cross-border activities of foundations are, due to differences in legislation of member states, costly and cumbersome. The European Commission's proposal for a European Foundation Statute recognizes the important social and economic role of foundations. It would facilitate cross-border work of foundations and would reduce costs and uncertainty. It would also allow foundations to benefit from more visibility to promote their activity and attract more funding thanks to a European label. The negotiations on this proposal are ongoing in the Council and the European Parliament, and the outcome of these has to be awaited. You are aware that the Jury Committee in the European Parliament has adopted its very supportive interim report on this proposal this week, while in the Council, a presidency compromise text is being discussed. One of the most difficult points in the Council concerns the tax treatment that should be given to European foundations. In the Commission's view, such an important practical and financial issue should be covered by the statute. This proposal is a priority for the Commission, and the support from the foundation sector is very important. It shows the European legislator that the proposal is supported by European civil society. It shows that there is currently a problem in this area, and finally, that there is a clear way forward. I wish you an interesting and fruitful session on the European Foundation Statute. Yours sincerely, Michel Barnier. So after that statement from the Commission, I'd like to hand over the floor to a representative of one of the Member States, and to invite Victor Kjær, Deputy Director General of the Danish Business Authority, to talk about regulation of foundations in Denmark, of course, but also, in particular, the proposal for the European Foundation Statute and the role that the Danish presidency has had in kicking off that discussion.
Thank you very much, and thank you for inviting me to come here this afternoon. It's great to see an audience that big late Friday afternoon on such a difficult topic as this, but also, of course, I think it is an expression that the topic is very important. As was introduced by the moderator, I'm going to say a little bit about what foundation means in Denmark, and because that also, I think to some degree at least, influences our position with regard to the proposal. So I'd like to say that foundations play a crucial role, not only in Danish society and like you see in many other countries, in way of philanthropic activities and being, key players in ensuring some of our main cultural institutions and societal activities, but also in Denmark as owners of the largest Danish companies. So in Denmark you will see foundations for almost all of them having a double purpose, a double objective, both being responsible for carrying out important large businesses and enterprises in Denmark, but also in parallel having important philanthropic activities. In Denmark, commercial foundations have been regulated by law since 1985, a law which is called Law on Commercial Foundations. It was passed together with the law on non-commercial foundations, law on foundations and certain associations. And the key elements of those two pieces of legislation have remained unchanged since their entry into force. But in 2009, the Danish Parliament passed a new Companies Act, which significantly changed the rule for public and private limited companies. And as many of the rules in the existing law on commercial foundations rely on the Companies Act, the new regulation for companies has resulted in a need to look at the influence from the new Companies Act on the law on commercial foundations. At the same time, this need to look at the regulation stems from the increased focus in society on social responsibility, transparency, and corporate governance. And I would say that, the financial crisis has reinforced this, I would call it desire in the public debate to have more knowledge, more transparency, and also I would say more certainty as regards the rules for commercial foundations in Denmark. As I mentioned, they are responsible for our largest companies and thereby also responsible for how a large part of our economy develops. So from that reason, from that perspective also, the foundations, the commercial foundations are very much in a political focus also in Denmark and part of the political debate. And on these grounds, the Danish government has decided to modernize the law on commercial foundations. As part of the preparations for these changes, the Danish government in the last year set up a committee which should come up with a list of changes to implement in the law on commercial foundations and modernizations and other word of the existing legislation. And this committee was very, I think you have to recognize that. They were certainly very efficient in their work because they accomplished their task in not more than half a year. They actually delivered their report December last year. I should say about the committee that, of course, it represented not only foundations but also business organizations, trade unions, and so it was really a broad representation of stakeholders. And what both as a government official, but I also think my minister as a politician was very satisfied with was the fact that the committee ended up, at least on most of its recommendations, to be in unison. So there were a general agreement on the recommendations that were given to the government. Now the recommendations touches on first of all, a modernization or a general modernization of the legal basis for commercial foundations in Denmark, but also increased transparency regarding the activities of the governing board and distribution of funds. And I think you have to understand also, again, the role of the Danish foundations being responsible for the largest Danish companies. There is a desire on the part of media, politicians to know a little bit more on what is going on in these foundations because they don't have general assemblies as a public limited company would have. So you can't in that fashion have knowledge on what is going on, why is the board deciding what it is, how are the general activities of the foundation. So there's an interest to have more transparency about the governance, about the activities of the boards of the funds. Finally, there was also recommendations on strengthening of the supervisory authority in relation to the governing board. So I think that is probably. Perhaps I could go a little bit, just a few minutes to say a little bit more about the recommendations. In the first place, I would like to mention that the committee has proposed that the supervisory authority should have enhanced powers and better possibilities for supervision. There is also suggestions for increased demands for the auditor, especially concerning duties to inform the supervisory authority about possible irregularities in the foundation. Moreover, the committee has suggested there should be stricter requirements concerning an independent management of commercial foundations, and there should be a requirement for commercial foundations to adhere to a set of recommendations for good corporate governance. You would probably be aware that for listed companies, for some years now, there has been a requirement in Europe that there should be corporate governance rules governing the management of listed companies on a comply or explain basis. And the intention of the committee is that a similar set of rules should be introduced for commercial foundations. So there would be specific rules for governance of commercial foundations on a comply or explain basis. And actually that there should be set up a specific committee to oversee the elaboration of such rules and their implementation in practice. I think this is some of the main points I would like to mention. Now turning to the proposal for a European Foundation, as was said by the Moderator, Denmark during its presidency in the first half of last year, started up the council negotiations. There were 2 working party meetings being conducted during the Danish presidency, and actually a large part of the proposal was examined. Afterwards, the Cyprus presidency conducted 2 more meetings and examined the remaining parts of the proposal. At the latest, the Irish presidency has come up with a compromise proposal, as was mentioned, but unfortunately there has not been a chance to discuss it at the working party yet in Brussels. So you will probably understand that I can't discuss details. I am pending a proposal from the presidency, but neither can I make detailed references to the ongoing discussions in the council. At least in Denmark, government officials are not allowed to do that when the negotiations in the council are still running. But I can assure you that from a general point of view, we support the aim of the proposal, which is to remove unnecessary burdens encountered by public benefit purpose foundations when they operate across borders in the European Union. As you may know, Denmark is a small country, and our interest is to make cross-border operations as easy as possible, not just for foundation, but also for businesses and citizens. And if you look at business, Denmark was actually one of the first, if not the first, European countries to adopt rules on, for instance, cross-border mergers for public limited companies. So we are very open on that account. But naturally, as this is said, we must also take into account the consequences and impacts of the FE statute or other policy options that could increase cross-border operations. Therefore, we are working actively and constructively to make the proposal robust enough to achieve the set aim, whilst avoiding that the proposal will lead to discrimination of national foundations or create other serious problems for various stakeholders. In Denmark, the ongoing work on the European Foundation Statute is rooted in my agency, the Danish Business Authority, which is part of the Danish Ministry of Business and Growth. We cooperate with the Ministry of Justice, the Ministry of Taxation, and the Ministry of Employment, as the proposal includes provisions that concern areas of competence where these ministries are responsible. We do not have data on the cross-border activities of commercial foundations in Denmark, but we know that some foundations operate across European borders, but mostly it is the foundation subsidiaries that operate across borders, as I mentioned, as owners in Denmark, commercial foundations as owners of public limited companies. You will see that those public limited companies have, to a large degree, I would say, cross-border activities. So in fact, we are not aware that Danish foundations encounter significant problems when operating cross-border, and even before the Commission came up with their proposal, and it was still, there were reflections going on with such a proposal being needed. We, with a very open mind, we had very open public consultations on this issue, and we didn't have strong voices in the Danish community, business organizations, foundations, so forth, that said this would really be a help, and we have a major problems today because of lack of such a proposals. So this is situation on our part. Of course, we know from the hearing conducted by the Commission that many members of the EFC, including a number of Danish foundations associations, see the European Foundation Statute as very important for establishing a European level playing field that will make it easier and less costly to operate across borders. And we have sympathy for that, even if perhaps Danish players in the field are not directly concerned about that. We want to, also be able to look wider than our own narrow national interests in this. And this is also our point of departure for going into the negotiations in Brussels. And we are certainly aware that there can be positive effects stemming from a foundation statute. So that we will, with that in mind, participate in a constructive manner in the discussions which are now taking place. But it has to be borne in mind that we are facing great difficulties along the way towards a final solution. And the meetings that has taken place until now have resulted in a huge catalogue of issues that have been raised from all member countries, I would say. Some of them, of course, very technical, others of a more, principled nature. So my judgment would be that it will take a long time before this proposal will be ready for any kind of decision. And that is not, that is not rare. We often see that in particular in areas where, the European Union is regulating for the first time, and in particular in an area like this where, national traditions are very different. Foundations play different roles. They are regulated in different ways. There's the issue of taxation, which was mentioned, and we have to overcome all of this. And in the first place, we have to understand as authorities how foundations are tackled in the different member countries. And as was mentioned, we have this particular challenge, which is perhaps more for political nature, that the statute has to be adopted with unanimity. I don't know how many of you are, have a deep understanding of negotiation process in Brussels, but just to say that, most proposals regarding the single market, the internal market, are now adopted by qualified majority. This, of course, put a pressure on member states to be flexible, trying to seek compromises, because you never know if you're going to end up in a minority of countries, and then you will have lost any bargaining power, whatever. But when you have unanimity, you can always, this. I'm not saying this is done consciously, but subconsciously, you are perhaps less. You have perhaps less. Incentive to be flexible and open-minded in the negotiations, because you can always stand on your national positions. So of course this doesn't make negotiations easier. And we have seen other statutes, for instance, for a European company, and which took really many years to get through council because of this. So this, of course, for those of you who would like a speedy result, this is a major challenge, and it is there, and I don't think there's much we can do about it. But I would say, however, just to not to remove all hope, that it is our impression, not just under our presidency, but also on the following presidencies, that there's really a will on the part of member states to negotiate constructively on that. So it's not, negotiations are not taking place in a hostile atmosphere. People are trying to be constructive, and this, of course, gives some hope that we can reach a positive result. So this is the general position as it is now. I would find it absolutely impossible to pronounce myself on the prospects for when at all could one imagine this proposal being adopted. I simply think it's too early. Perhaps my Spanish colleague has another opinion on that, but that would be my judgment as things stand now. Thank you very much.
Thank you very much indeed for that very clear presentation. It's very interesting to see how the considerations at national level also inform this debate at European level. It's also very heartening to hear that even if you do not see immediately a clear demand domestically, that you are willing to negotiate at the European level to produce a constructive solution. I think that's very important. So thank you.
Thank you.
Do we have any questions directly to Mr. Kjær? Okay, then I would move on to our next speaker. We still take a Danish perspective, but now from not from the position of the government, but from the position of an academic expert who has had many years of experience in European company law in general, and including on the question of the Foundation Statute. Søren, as I said, is a professor at Copenhagen Business School, and the floor is yours. Next 10 minutes?
Yep, sure.
Great, thank you.
Do I need to turn this on?
No.
It's on. Right. Thank you very much. I have been working with the European Foundation since 2003, when I joined an expert group based in Hamburg, and we worked on a proposal for some years. Now, just a brief commentary from the Danish position. Now, we have this notion of commercial foundations in Denmark and indeed in Scandinavia. Now, while some other European countries have restrictions on foundations carrying out economic activities and business activities, and because we only got the Danish Foundation Act in 1985, at that time commercial foundations did exist, so it would have been very hard for us to prohibit them. So instead we chose to regulate them. And this is why we have got this distinction between commercial and non-commercial foundations. Now, what's an important point here is that the commercial foundations have as their object to run some kind of business. Carlsberg, Novo, Velux, and other very large Danish businesses are run by a public limited company which is controlled by a foundation. But the purpose of these commercial foundations, almost all of these commercial foundations has a purpose which is considered to be public benefit. And this is because of tax, because ever since the 18th century in Denmark we've had tax privileges for public benefit foundations. And this is important from a Danish perspective because this allows most of the commercial foundations would be able to use the FE statute if and hopefully when it will be adopted. Now, as you know, the SE, the European Public Company, was debated for something like 30 years. We don't hope we have to wait that long, but nevertheless, it's very good to hear that there is some progress nevertheless. Now, turning to the European perspectives, we find that foundation law is not harmonized. And this is because the provisions on harmonizing company law in the treaty does not cover non-benefit organizations, non-commercial organizations, such as foundations. We've harmonized rules for public and private companies, but not for foundations. However, this does not mean that foundations are not subject to European law. Profit foundations, such as the Danish commercial foundations, would be able to rely on the rules of freedom of establishment in Article 49, the rules on freedom to provide services in Article 56, because they carry out economic activities. Non-profit foundations, that is, foundations which only has some funds which they use as a basis for income to donate to the public benefit purpose, cannot rely on the freedom of establishment. But as we've seen in the important case from the European Court called Stauffer, such foundations can rely on the free movement of capital. In the case, there was a real estate owned by an Italian foundation in Germany, and that fell under the scope of the free movement of capital. So even non-profit foundations can rely on the freedoms in the European treaties. And in the other important benchmark case from the European Court called Kjær, it was established that a donation from a German national to a Portuguese foundation fell within the scope of the free movement of capital. So even people donating funds to a non-profit foundation would find themselves being able to rely on the freedoms in the European Treaty. And this is a very important basis for the discussion, because this means that foundations are indeed, to a certain extent anyway, covered by European law and the freedoms in the treaty, which are applicable to normal companies. Not in the full extent, but even the non-profit foundations can rely on European law. Now, the work on the FE has started for real about in around year 2000. And as I said, I joined an expert group based in Hamburg, funded by the Bertelsmann Stiftung, and we worked parallel with the European Foundation Center to make up a draft statute for a regulation on the European foundations. Our work was published in the year 2006, and this expert group comprised of experts from many different member states. And the purpose of our work was to create a common reference that would be acceptable to all member states. So if we from the outset had some questions, we needed to solve them in a way that would not deter any member states from accepting this proposal. And we actually found that although there are many differences, especially with the United Kingdom, where the concept of foundation is somewhat different, we found that we had some common principles that we could put into this proposal. We did indeed find some common ground, although, again, many differences, but we managed to find some common ground. What is a foundation? How is it managed? And what is its public benefit purpose? Now, obviously, as Kjær said, there remain some controversial issues. One of which has already been debated is the definition of public benefit purpose found in the draft statute, Article 5. But if you look at it, you will find that it may not be that controversial after all, because in any way the definition is relatively broad, and from a Danish perspective I would certainly say that it would cover almost all of the public benefit foundations that we have would be able to fit in under one of the bullets in Article 5. That doesn't mean that there might be member states who still have some issues, but still, if you look at it, you might find that the problems are indeed solved. Another tricky question is the option introduced to transfer the registered office of the European Foundation, effectively removing it from the country of its origin and making it subject to the foundation rules in another member state. We have had a judgment in company law called the Vale judgment, which allows for public and private companies to transfer the registered office under the rule of right of establishment. And so this means that foundations which can rely on the right of establishment can actually already rely on this based on the Vale judgment. Again, perhaps the problems might be solved. One of the solutions might be to say that the management of the foundation should be located in the same member state as the registered office. But this is, of course, an issue for debate. If we look at Danish foundations and their cross-border activities, as Kjær mentioned, most of the commercial foundations in Scandinavia operate through a subsidiary public company, which means that that company has the full access to right of establishment, free movement of capital, free movement of workers, and free movement of services under the European treaties. However, we still find that foundations come into problems with cross-border activities. Let me mention a few examples of that. For instance, the rules on taxation of donors and recipients of donations from foundations differ from member state to member state, which means that if a Danish foundation gives a donation to a person resident in another member state, that donation might come into problems with tax. Furthermore, if a foreign foundation establishes a permanent establishment in Denmark, that permanent establishment would treat it for tax purposes as a permanent establishment of a public company and would not have access to the tax privileges given to foundations in Denmark. So here we have a problem in Denmark. Now, with regard to tax, a brief note on that. Most member states have been giving tax privileges to public benefit foundations for some hundred years. But again, as I mentioned, we have two landmark decisions from the European Court of Justice, the Stouffer decision and the Persia judgment, both of which saying that if a foreign foundations meet the national criteria for being a public benefit foundation, then that foundation having activities in another member state should be given the same tax privileges as the foundations of the member state in question. Already from the beginning, also in the expert group, we had some rules on tax. And I would strongly advise to keep that because that is one of the areas where we have practical problems, and I'm very pleased to hear that this seems to be the Commission's view as well, that tax rules are necessary. One small comment, maybe the problems here could also be solved, because only as far as the FE statute goes beyond what is said in Stouffer and Persia, there would be a problem because Stouffer and Persia are valid law today. And that means that only a foundation which does not meet only if the national tax rules of a member state does not say that a public benefit purpose is covered by Article 5, you have a problem. Because if the tax rules definition, if the tax definition of public benefit falls within the scope of Article 5, then that same treatment should already today be given to the foreign foundation based on Persian alpha. So maybe again here it would be possible to find a solution. Will Danish foundations use the FE? Well, as I mentioned, one very important point would be that the commercial foundations in Denmark, almost all, or even all of them, have already in place a public benefit purpose, and I would suggest that most of those public benefit purposes are covered by Article 5, which means that a Danish commercial foundation can rely on the FE statute, because if that was not possible, then the FE statute might not be very interesting from a Danish perspective. Even though many of the Danish foundations use subsidiaries, there should still be some advantages, especially creating legal certainty, legal recognition of the foundation, and certainly in the tax area, so that I hope that Danish foundations will indeed adopt the FE statute if and when it is adopted by the Council.
Thank you very much indeed. Very interesting. It's very helpful to see the concept, the development of a concept from the perspective of a real legal analysis of how you can come up with a solution that takes into consideration the particularities of each member state, but still produces a working solution that can address all these issues. That's very helpful to give us a background to the debate that is now happening within the Council among the member states, and you've identified issues of issues that are likely to cause concern, and I think now the question passes to Jorge Carrera from the Spanish Permanent Representation in Brussels, who's participating in these discussions. What are then the issues that are really causing concern among the member states? What is the process now from here in terms of resolving them? Just a couple of words of introduction. Jorge is a magistrate originally in the Spanish judiciary. He's now based in Brussels at the Permanent Representation and covering not just this but other issues of European company law. Thank you.
So thank you very much. Good afternoon to everybody. Thanks for thank you for inviting me here. I think it's very important to have this kind of dialogue between you and the institutions that are involved in this process. So I think my role here is more or less being like a bridge, broadcasting to you information about what's going on in the country and hearing about your concerns and try to process them and to bring them back to the council and try to help finding solutions on what this one seems to be a problem. And that's right, you have a problem, and let me start with, I would say, a little bit political approach instead of legal approach. Go there to the legal approach, because I think now it's about politics. Fundamentally, you have a political problem. There is need, yes, there is a need of another kind of foundations with the possibility of operating in different member states at the same time, because social needs another kind of needs. You don't know about borders, they operate, or they are in different countries at the same time, and we need structures that could operate in this manner. So, and you have identified a solution for this need, and the solution is the European Foundation, another kind of foundation that could operate in the whole Europe or at the same time in different countries in Europe. But this solution requires legislation, requires, in this case, a regulation, and this is about politics. This regulation, it's especially, I would like, tricky one, because it's not a normal regulation, it needs unanimity. And this is another political point that has to be taken into account at the same time. So, I think the most important point now is that you need a strategy. Otherwise, it would be difficult to go on with this solution that you've proposed. It's not a technical issue, it's a political issue as well. And you must be able to put the issue in the political agenda. Otherwise, it's not going to work. You need European founders, and in this case, you need 28. No one more, but no less. So, basis for the strategy in this case. Well, first of all, according to my point of view, this regulation makes an inroad into a very complicated issue, which is tax issue. It's really difficult at this stage, according to the Council's mood, to convince member states that it could be possible to have a regulation that makes an important inroad into tax issues. And you have a chapter that deals directly with taxes, which is important, and we can understand why. You've explained and you've put on the table many reasons on the needs, of the necessity of this chapter. But this is a political issue, this is a main issue. Additionally, it has to be taken in account that a legal approach on foundations and charities, it's not always the same in all European member states. And according to my knowledge, to my knowledge on the issue at this stage, and according to the discussions we have already had in the Council, there are some member states that do not have something like a foundation in their national legal framework. So it's like trying to introduce to their bodies an strange thing that could harm or could lead to some problems in the long term. So it's not easy. Some of them say, well, we do not have that kind of institutions. Why we have another kind of solutions to address social, cultural kind of issues. So why do we have to introduce, or why do we have to accept this specific solution? So you've identified as a solution what I would call, or it could be called, a hard approach. So a specific kind of institution and a specific kind of institution that affects directly to member states' tax competence. There are other approaches, of course, what I would call soft approaches, which perhaps could be taken into account. I'm not saying that this is my proposal. I'm just trying to analyze the situation. So, which is at this stage the Council's mood? Well, as you well mentioned, we've had already 4 meetings in the Working Party. And in the first meeting, well, things were a little bit complicated. The word, the headline, perhaps would be skepticism, even reluctancy could be a good word to put in this kind of headline that I'm trying to transmit, to show to you. So, skepticism, why? Because of need, of the opportunity. Do we really need this kind of a new legal institution? And why? And reluctance in some cases because of the tax issue. Well, we are proposing something that, well, we have not clear views on if we really need or we don't need. Tax issues are really an important issue, and especially if they are introduced in a regulation. So these were the 2 main concerns in this first meeting? Well, I was saying that I think there is need of a strategy, and at this stage, my point of view is that the current strategy has focused most of the Council's attention on the tax chapter. How to deal about that, how to deal about this issue, what to do. And I'm not very sure that this has brought advantages for the future of the project. Let me say it this way. So, how to proceed? Is there another alternative strategy? I'm very well aware that, for example, the Commission thinks that, well, tax issues are very important and must be there. And maybe the European Parliament, in some manner, shares this opinion. But of course, this is co-legislation, and at this stage, the opinion in the Council on tax issues is not the same. I think it's difficult to find or to strike unanimity in the Council. And on this issue, at this stage, I think there is unanimity. So it's a record in some way. So, well, different opinions, different points of view, but reality is reality. So, how to deal with this situation? In my point of view, I'm not speaking on behalf of the different governments that are involved in the Working Party. In some manner, I could say that I'm speaking on behalf of the Spanish government. Well, just in some manner. First of all, I would think about the possibility of going for a pure civil law instrument. Why? Well, you avoid a major problem. You leave tax issues on the hands of member states. Well, you can create an European Foundation, you can go along with this European Foundation, you can run the European Foundation, even you have some advantages creating the European Foundation, and then, well, every member state will decide how to deal with this or those European foundations that do operate in his area. It's a kind, I would say, of procrastination approach. You don't solve in one shot all the problems. Normally, life works this way. So, in legal life, maybe it's the same. So, you solve some important problems, and you leave others, and maybe then member states will start dealing with those European foundations, trying to find solutions in domestic terms for taxes and donors and and perhaps, well, with some time, they will start finding coherent approaches, and perhaps you will reach, well, it needs time, but you will reach the final goal. So, this could be an idea. Of course, at the same time, it would be interesting to try to improve, for example, in some points, the instrument. I'm not talking about very specific issues, but again, political issues, for example, trying to strengthen in some manner the supervisory powers and supervisory role of supervisory authorities. This would, I think it would be a good idea in order to try to convince member states, well, yes, those institutions will operate in your member states. Maybe you could grant them some tax advantages activities, but at the same time, well, you will have the possibility of establishing a supervisory system that really works and avoids some kind of abuses or some kind of conducts that could not be appropriate, and perhaps you are fearing about the possibility of them. So, and finally, I will try to build a kind of communication campaign or strategy. I think it's very important. You need 28, not 29, not 27, you need 28. It's a very tricky, very difficult election. And you have to knock every door, and you have to spell. And you have to be able to transmit the advantages of the system. Why? And perhaps, let me give you an idea that I'm not sure it could work, but it's an idea. Sometimes stakeholders are invited to our sessions in working parties, and they have the opportunity to establish a dialogue, to communicate, to explain. This is very important. And don't make very technical explanations. No. I think go, for example, audiovisual, and show in a very easy way why it's important, which are the costs. For example, if I have a foundation which was established in Germany and I want to operate in Spain, in Italy, in Belgium and in Denmark, and I have to register in every country, and which is the situation if I can create this foundation in Germany and then it works. It's workable in any other European country. Show it. They have to touch, to see. It's much more important than going there and making a beautiful, technical, legal speech. So, this is my first approach, first ideas. Then, I think I'm here in order to try to explain a little bit to you, well, which are the main concerns on the instrument, on the regulation of these states in the Council. Well, I'm going to be brief because I think the most important part of this event is the dialogue that we can establish afterwards. But, well, first of all, that chapter, it's clear, it's absolutely clear. We have, for example, Spain has a reservation. Every single country has a reservation on this chapter, so it's unanimity there. Then, another point, for example, Article 5, the different activities for a European foundation. Well, for example, we have included, it's quite exhaustive, this list, but we have included, because we think it's important for us, for example, it's important support for victims of terrorism and violence, and in another case would be, for example, promotion of interreligious dialogue, which I think is important. Maybe somebody is already included there, but okay, another two. But well, it's not a major issue. Article 6. This could be a major issue. I think we have a more flexible approach here, because this article says something that is a little bit surprising. If you want to be an European foundation, you have to have as a statutory objective carry out activities in at least 2 member states. But you do really have to carry out all the time activities in 2 member states. It's not going to work. Because maybe sometimes you will have, well, yes, I'm starting, I'm working in Germany, in Spain, in Italy, then, well, I have no more funding, I have to stop in Germany, in Italy, I continue in Spain. Well, I have to reconvert my foundation to a national foundation, and then 6 months later, when I have the possibility of continuing working in another European, then creating a way, well, I think it's not working. So we are proposing, for example, the European Foundation shall have a statutory objective of carrying out activities in at least 2 member states, and shall effectively have, through its lifetime, the aim to carry out regularly such activities in at least 2 member states. think it's more flexible, more realistic. So, for example, I think it would be interesting for the Council, for us as well, to engage in a dialogue on a debate on the Article 7.3 in order to decide if there is more flexibility, there is need of more flexibility or not. I think it's another interesting point that could be discussed. Okay. And then I'm really going a little bit fast because I have 2 minutes, so 2 opportunities, 2 shots more. Let me see another point which could be important. Well, we very much, and this is not a major issue. I think maybe all member states do very much welcome the deletion on the volunteers, the participation of the volunteers in articles. I think it was 38 and 39. That was another tricky point. I think every foundation could decide on this issue, and there is no need for a general provision in the regulation. And then, well, this is not a major issue. Article 44, for example, when a foundation stops its the activity, well, here it says that the remaining assets should go to another foundation. We say another foundation, preferably based in the same member state in which is registered, because perhaps it's easier to find and it's more coherent to try to find another foundation based. This would be the first preference, if not possible, of course. Then the assets would go to another kind of European foundation. So, just I finish here, just to bring you a general view, and then very happy to continue talking on the issue. Thank you.
Thank you very much. It's very, very valuable for you to come here and to explain your perspective, explain and help us and advise us in how to proceed. That's really a very, very valuable contribution. Thank you. And finally, I pass the floor to Evelyn Regner, member of the European Parliament. Welcome. Ms. Regner is a lawyer by training herself. She's an Austrian Social Democrat member of the European Parliament in the Legal Affairs Committee, and was the rapporteur of that committee on the Foundation Statute proposal, which was adopted by the committee just yesterday, and will now go to the plenary. So we would be fascinated to hear from you on the Parliament's position and on the procedure from here on. Thank you.
Thank you very much for the invitation, and I just really in the beginning congratulate the organizers for the timing. Outside there is weather for all those coming from Brussels that is so brilliant and overwhelming, and secondly, as you already mentioned, for the timing, because we had the vote just yesterday, so somehow I just really had to pass through the compromise amendments, what went through, what didn't go through, in order to have the full picture right now. I would like to share, and also a little bit to add to what already has been said before, from a more personal view. When we got the topic on the table, when I just heard, okay, it's now about a Statute for European Foundation, I just have to say, as being Austrian, I was just somehow a bit hesitating. If you translate it directly, the word Stiftung in Austria somehow makes people a bit, how should I say, carefully looking into the detail of what's presented, because it's always a question, what sort of foundation? I simply would like to introduce that, because somehow when approaching to the whole topic, one shouldn't underestimate that when you just take this word, and we have right now a couple of cases in front of our courts where people somehow didn't do the right things and didn't use the money on the right purpose that should have been dealt with. So somehow that's just simply an introduction concerning the general political backgrounds, at least in my home country. Then, of course, when digging deeper and looking at the Commission's proposal, the situation was completely different. So I just would like to say very briefly what the position of the European Parliament is concerning the proposal. First of all, we are a bit different than the member states, also because of many reasons. So somehow it's always the question where the competences and what competences we don't really have in this case. So somehow our approach is a very European one, more or less cross-party and cross, one could really say, all over Europe. So in general, I just really could say that the Commission's proposal is welcomed concerning more or less all major conditions that are in the proposal. We were just simply looking at it, and that's something I also would like to stress, taking the whole picture of European company law. I think that's very important to say. Commissioner Barnier's approach is the one having in mind not only the foundation, but also the mutuals, also the European Cooperative Society. And this is also right now reflected in the position of the European Parliament to have this coherent approach. So therefore, somehow we also supporting the approach for boosting, or not boosting, but at least trying to step by step do something for the internal market in order to get a little bit more growth, and just really looking, okay, what's feasible, what's not feasible, concerning every activity that is cross-border and it is good for social investments and the whole public purpose. So some before I come to the finally to the final compromises, some personal observations concerning those approaching right now the European Parliament and those really having had interest in the whole issue. Of course, all those dealing professionally with foundations, where there is really a clear need that you say, okay, we would like to go cross-border. My personal impression was concerning those who really tried to submit their positions, that it's specifically those representing foundations from France and from Spain had the biggest interest. It was not so much Denmark, at least they didn't do this direct lobbying, but it was first of all also with very clear and good explanations why cultural foundations and why foundation with a social purpose from those two countries are really pushing the topic and giving good explanations. One barrier I was observing, also going to the barriers, and then just simply mentioning it because it wasn't mentioned before, so I don't want to talk too much about all these questions that have been already put on the table, was also the question concerning the trust in business registers. So somehow there are throughout also objections, because somehow when we are more or less opening business registers for a new European company form, somehow it's also very important to approach concerning the business registers, and of course we are already advancing right now with the interconnection of business registers, but there is also a long way to go in order to strengthen the trust in new company forms that have to live afterwards. I don't want to say too much about the taxes, because the tax question is really something we more or less left out, or more or less kept very sober and short in our report. The reason is clear. So somehow that's really the question whether Council working parties have to come closer. It's not that the European Parliament is not eagerly discussing the whole topic, but somehow it doesn't make sense to give good proposals, and somehow it's the Council who has to decide on that. So it wouldn't be very wise to stick to this issue. Somehow concerning the compromises right now we found, I just would like to put out very short, very quickly some issues. One is simply, I just have to throw it out because we always have to put the final result together, so sometimes one really has to look what was then finally, when you put all these amendments on the table, what was finally voted on. Somehow, just simply to state, where existing statutes have become inappropriate for the functioning of the European foundations, they are made by its governing, where the European Foundation has other bodies in accordance with Article 31. These bodies should be involved in the decision of the amendments to the statutes. So that was one of the compromises. Another one was dealing with somehow dealing with the question open-ended or not, or only for a certain time, because it was really also a question, because we're always discussing, okay, where could be abuse or not, or where could we go for it. So we just stated that normally the European Foundation should be open-ended, but it could be also possible that it's shorter, but then it really has to be a time somehow. How should I just say the wording, or where less, where expressively laid down in its statutes for a specified period of time of not less than 4 years. So we put in those 4 years, and otherwise it should be really a sufficient justification for doing so when it's for 2 years. So that was also something we really discussed. Maybe 2 issues, I don't want to say too much, but maybe 2 issues where we really had huge discussions, and I think there was also more or less those dealing with the whole topic not being very happy with what I was submitting in the beginning. We had to find a compromise because, of course, there are different political approaches, was the question of remuneration. Whatever we're doing at European level, it shouldn't be an abuse possible. I think here we completely agree, and therefore we really have to be very careful somehow when we're dealing with the topic of remuneration. And so the compromise we found finally was that there should be not disproportionate compensation, and there was really a wording that we were fighting for. So I'm pretty sure the same discussion is running in the council. So somehow we are really fighting for these expressions. But I think somehow, especially in these times when we're fighting against tax havens and everything else, we shouldn't find any loophole for a European company form that could be maybe used in a way that is not the proper one. And the final point I would like to make is, and because that was raised by you right now, but I would like to add it, was the question of the volunteers. Of course, the foundation sector is one of those where you have people being fully committed for a good purpose, who would like to contribute for a good thing, where the purpose is that laid down in the foundation. And of course, a volunteer is a volunteer. But I think here the Commission really tried to, they really did a good proposal when they said, okay, let's not forget completely about the volunteers and their role, and to include them, give them some information. And I just put that on the table because, it was not discussed so far, but I think we really should take that on board right now. And thinking of maybe another form or another direction this European Foundation could go, as we are discussing right now, as they are existing at national level. What do I mean by that? We got today the data of the unemployment rates all over Europe, and I just focus on one. We have a youth unemployment rate in Spain more than 50%, in Greece more than 60%, and in many other countries it's I don't know where. And I'm just putting that right now on the table because it already happens, and we shouldn't close our eyes in front of this fact that young people who are absolutely willing to work, who have learned something, of course are doing more and more in order to use their time properly in a sector where more or less offering their volunteer participation. So of course it's a good thing, and in so many curricula vitae you just want that you see, okay, that's not only a person who has work experience, but who's giving something of his life, of his knowledge. And therefore I was really fighting somehow to that those volunteers, of course they are volunteers, they're not working, and I'm talking a little bit more about those who are not the classic ones in the foundations, should also be respected and at least given the proper information. It's not somehow feasible right now concerning not only the political approaches in different parties, it's also somehow when we're thinking about a foundation, we have a completely different picture of a foundation, how it works. But we should simply take that on board for the further discussions, because we already have examples where young people more or less are working for nothing and somehow regard that as their entrance in the labor market, and at least they should be involved a little bit more concerning the information. That was really something coming from my heart. What was not mentioned too by you so far, but was the whole question of information consultation involvement of workers. Of course, it's not a huge issue with the European Foundation, because we are talking always about a company form where somehow you don't have so many, you don't have European Works Councils in the broad sense, and I completely understand that. It just simply reminds the Council, and here we have, I would say, a strong reference in it. We have to stick with this, what has been already decided with other company law forms, because European company forms, because here we should really respect coherence, and somehow, of course, it's a very sensitive issue, and I completely understand. The Spanish model is completely different than, for example, the German model, but here we simply have to find a way along the line. We also have to discuss, and therefore I didn't mention that because that's the huge topic. It is more or less the topic dealing with it, the whole tax topic. So I simply would have wanted to add all this. Generally, again, the European Parliament is very much in favor of the European Foundation and really gives a backing for Commissioner Barnier, but is simply aware that the major questions this time have to be, first of all, discussed and solved by the Council. Thanks.
Thank you. Thank you very much indeed. Thank you, first of all, on behalf of the EFC and the Foundation Sector as the rapporteur for the support for the statute, which has been so much supported by the section and by the Centre. Thank you also for showing how much there is in this. Even if you take the tax chapter out, there's still so much subject for discussion and negotiation and debate. But I just come back to the Parliament's position on that. I know there was an amendment to remove the tax chapter, but you decided not to do that, but to include proposals for more reflection. Why did you opt for that direction in the end? What was the content of the discussions on it?
Yeah, so somehow it's the European Parliament. I just tell you, a parliamentarian always wants to give a contribution, wants to participate, wants to put something in, even if more or less in this case somehow it's clear who really will more or less decide. So that was first of all a question of principle.
Okay, thank you. Then we turn to you. I think it makes sense to keep on tax for the time being because that's obviously such a key issue. But then maybe we can still look at others in the remaining 10 minutes or so that we have. Can I turn to Friis straight away? Friis has been very engaged in the campaign for a European Foundation Statute for many years. If you were to take this tax chapter out, I've heard some other member states say, well then the statute wouldn't have any added value. So what added value would it have if that tax chapter wasn't there?
Thank you. First, thank you for the panelists because it had been very interesting to see where the reservation and the space of room for discussion. And so, as you say, it's we can proceed by step. And for us, what's important, at first, it's a question of the civil law, and it would be very important to have a uniform text for foundation in Europe, which is which is optional, obviously. Like that, every country can keep its legislation, but we will have something which is really a tool for citizens. And for us, it's something very important because we have been working, as you say, for 10 years, 12 years on that, and we are convinced of that. The question of a tax issue, this question, it's not a question, in fact, of foundation. It's a European question, and it's the most important question today between states and the fiscal question and the equality of tax, equality of situation in the various countries. And I don't think it could be solved just in putting it in the statutes, which is a small thing beside. But besides the small thing, there is a huge question of the tax issue. And the tax issue is so complicated that I'm sure if we have that, the statute will never exist. So the civil law would be for us a huge step. And I want to come back what you said. You perhaps in Denmark you have not a big support because not many foundations are working in such situation. But in other countries, some countries need it. You talk about France and Spain and other countries. So it's a kind of situation where it's not because we expect that. It's not because some countries are not interested in. If they have no reservation, we try to persuade them that not to vote against, because they will not use it, but some other country were 28, perhaps 10 will use it, and in 10 years, 25 use it. And in 5 years, 10 years, when the system, European will progress, we will have when the fiscal question will be solved at the level of Europe, it will become natural for the foundation to come in a chapter of that, but it will be at the other way to cope with that. So it answers perhaps your question, but for us, we understood that there is some article we can be discussed. It's what we are ready for. There are some possibility. We hear that since the beginning, through the 4 meetings, there is a progress. We had to work with Parliament also, and so things are going on quite smoothly, we can say, and it will not be 30 years as you say, because the status of association is also a very, very old thing. So if we can succeed in that, we will be very happy. Thank you.
Would anybody else from the audience like to ask the panel any questions? Please.
Thank you. My name is Aart de Geus, Chairman of the Bertelsmann Stiftung. Thank you very much for this very comprehensive view, and also the panelists. I think it's an excellent initiative. Thank you also for your comments. I have one question. In the past, maybe foundations themselves could help to facilitate a creative debate on what could be the statute for foundations, like Bertelsmann has done and others. What could be the role of foundations in this time? Is there a lack of creativity? Should there be lobby? Should there be public pressure? What could be nowadays the role for us as foundation to help this plan to come through?
Thank you. Pass right to Colin.
I too found the panel discussion very interesting and very informative. I'm from Ireland, and Ireland has the presidency at the moment, and I just thought it would be interesting to pass on some of the comments that I've heard as Ireland chairs the discussions, and they reflect very much the points that have been made. But first of all, a lot of progress has been made. There's a lot of consultation with the 7 member states, and the issues that were causing agreement and disagreement were identified, and a new proposal has been put forward, an amended proposal, and that's going to be discussed at the meeting on the 26th of June. There was going to be a previous meeting on the 7th of May, but a strike by officials in Brussels prohibited it. So that's a bit of a pity, but it's only a blip. But the chair of the meeting said to me, I am getting pressure, I'm getting representation, strong representations from the EFC, from foundations, from the philanthropic agencies in Ireland to push this forward. But she said, I'm not getting a lot of pressure from the member states. And I think that this is an issue that we need to take into account. Well, why is that? It's very hard to get unanimity if there are not strong advocates for it. And I think that we need to convince decision makers, and by that I mean politicians and senior civil servants, of the benefits of the statute, but also of the cost to citizens' lives, to the lives of European citizens, of not doing that. And I think that we need to consider, again, how we are presenting the arguments for this. And I think that there's room for improvement so that we can tackle the decision maker, the politicians and the civil servants. And there's one other point that has come out, and that is the issue of tax. The chair said to me, is the statute a valid instrument if tax is not included? And I said, yes. I said, because she said, if you are insisting on pursuing the tax issue, this will not go ahead. She said there are objections from all of the member states for some aspect of tax. And I think we have to consider whether we want the statute, with or without tax, and whether we, if we pursue it, we're going to kill a good statute by seeking the perfect one.
We take one more from the audience, then I think we need to give the panelists a chance to respond.
Got a very simple question for Mr. Carrera. My name is Marco De Maria. I'm Italian from São Paulo. I'm not asking him to rise the veil of discretion, but if, theoretically speaking, one should wonder which among the various member states is less skeptical about the introduction of the Foundation Statute, which states would you mention? Because perhaps if we had to aggress with our campaign, as you mentioned before, the political core of the problem, we should, with better start where the front of the resistance is weakest.
Okay, one more.
From the Better Foundation Poland. I would like to pick up from what Mark and I would put this question a little differently. I believe what is important for us is rather not to look where is the strongest resistance, but where we do have allies. Because it's really so in the position of the Polish government, which is moderately for the adoption. I'm saying moderately for, because they feel safe saying that the others are against, so they can be brave to say we are for it. What we need is to tell them that there are others who are for it and who are even more for it than they are. So I believe you should look for those who want to endorse this statute and not to those who are resistance. But one very more important thing is, I mean, the ball is in our garden, or on our field, as it says in Poland. We have to think about the convincing argument. Because the position of the Polish government was, it said we are for it, but we are not convinced. The arguments that were presented in the statute for the need for it were not convincing. And it's not the European Commission that must convince our national governments that it's needed, it's us. So there is a job to convince them that they need it, that it's not something which threatens them or NGO sector. Because another useful argument which was used during the discussion with the Polish parliamentarians, some of them from the opposition were questioning the need for the statute. The government said, but the Polish government sector was for it. Polish foundations were for it. And they were even surprised that they were for it because they felt that the statute is threatening national Polish foundations because it means that there will be these European foundations who will come and take all the profits from and all the money from the sector. So Polish foundations are for it, and but they have to find the ways to convince the government that it doesn't threaten them, but doesn't mean that there will be less tax left in Poland, and that this little wealth that's being accumulating there is going to be taken abroad. And one very useful argument to tell them what is necessary is because of the mobility. You know, almost 1 million Poles are not in Poland anymore. They are, you know, in different parts of Europe, they are in different other countries. So that's why we need European Foundation, not Polish foundations, because Poles are not in Poland anymore.
Thank you. Right, so to the panel. Responding to both the questions and the comments that you've heard, would you like to make a final statement?
Perhaps just very briefly to say, I think the one gentleman raised the issue of being more active as a stakeholder, and from the perspective of the foundation, at least when you look at the situation in Denmark, we have no association of foundations in Denmark, and when we try to make up a position on the new European Union proposal, we have a broad consultation with stakeholders. But if there are no stakeholders there voicing considerable interest in a project, well, then we listen to whoever are there, and if they are very reserved about the need for a new proposal, this is going to be the position. And I think when I look at the different the sector of foundations, they're perhaps not that used to entering into political processes, so perhaps they are somewhat handicapped in that sense compared to, for instance, ordinary companies who are certainly used to being very active in all political decision-making processes. Thank you.
Thank you.
Thank you. Just a brief comment on tax. I'm well aware of the skepticism because it was raised already during the work we did in the Bertelsmann Stiftung work. But we should again be aware that once the European Court allowed a non-profit foundation to rely on the free movement of capital, it sort of opens this access road for foundations to apply their national tax rules abroad. And the question we should ask ourselves is not what will it cost the member states to introduce the FE, but rather what benefits do we lose by not introducing the FE to the European society.
Thank you. Okay.
Well, so please understand that I'm not allowed to reveal here specific positions of member states, but what I would like to say is that tax issue is casting a kind of shadow to the rest of the instrument, and it doesn't help. So, hard approach, soft approach. In my point of view, if finally it's soft approach, perhaps it could be easier. If there is a significant number of member states that can go along, then it's more easier to convince the rest. So I think perhaps we need two kind of tools. Legal one, perhaps a switch on the approach of the proposal, and the other one, which is more up to you, a sound and clear strategy in order to explain and communicate, and activity. Very much, you need to act, to react, to knock every door, and to explain. And I agree. I have to. It's important, for example, to explain to member states which are the costs of not having the opportunity of having a European foundation. But this is not an easy exercise. Maybe for you, for member states, it's not that easy. So it's up to you to show them how could it work with European foundation.
Thank you very much. I simply would like to have a positive outlook. When we're looking to the European company that was already quoted before, it took so many years, decades, until we got it. And then when it started to live, everybody was asking, and I mean, it's getting so slowly right now. Company law simply needs time in order to be applied, in order to be successful. But now when we're just looking, there are already quite many European companies. And as with the other European company forms, the same thing. My observation is, and I understand that the national authority, especially the judges and the whole legal system, is thinking and acting in a very national way. So somehow, of course, it has to be done carefully, that's clear. But I think simply, and in this regard, I would simply put something positive on the table. What we ask for very clearly, and Commissioner Reding also supports us in the European Parliament, simply also in investing in further education for judicial training we could more or less support also the creation of new European company forms. And somehow that's only one piece of the whole mosaic when it comes right now to this new form of the European Foundation, when we are asking all the time, how could we convince where there is the added value, that we simply should also focus on this judicial training. So somehow my conclusion simply is this one: we have to be patient, we have to stick to the topic, and slowly but slowly we are moving forward to the right direction.
Thank you. I think just one last statement, because I think your question there was also directed at foundations, not just at our panelists here. Maybe I could just ask Rosa on behalf of the network of foundation associations to respond to that question about what should foundations be doing? Should they not be, or have they lost some creativity? Do we need to maybe relaunch the communication campaign on this?
Thank you, John. Well, I think what has happened is that the process is long, and we have to be patient. And somehow the EFC and the national associations have been taking the lead on this in order to be able to answer to the technicalities. We've been focusing very much in studying the text and trying to find what are the things that can be improved and what answers can we give to the questions that are posed by member states or were posed by the parliament. And we have been doing this intensively, probably for the last year basically, and then before, to prepare this. And now it is the time, and I think I will take Mr. Carrera's words. It is the time not to be so technical. We will always be there for the answering the technical questions, but we have to be visual. We have to convince the national authorities what is the value of the work that you do. And there's nobody better than you as foundation that can explain what is the value of your work. So it is the time really for foundations to speak loud about the value of the work that you are doing and how this work can be enhanced by the possibility of working cross borders without so many rigid restrictions.
Thank you. I think I would just add to that by referring back to that little straw poll we did at the beginning. It's clear that the European Foundation Statute is not necessarily going to be a legal instrument that every foundation in Europe is going to want to use, could use, is appropriate for it. But if it is to exist at all, for those that could make use of it, it requires 28 votes in the Council of Ministers. And so it is essential that every member state can be convinced by the relevant sector in those member states that it's something that they should support. Thank you very much all for your attention. Thank you for staying on so late on a Friday evening in such good numbers, and I wish you a very pleasant evening and final continuation of the conference.
What time is it? 10 past.